Hey class, today we're going to talk about the sources and ordering, the precedents of American law. And that leads us to our very first question of the class, which is, what is law? Law formally are the rules and regulations made and enforced by a government that regulate the conduct of people within a society. You should know they're completely different than morality, okay? Actions by people are regulated by the government. That doesn't mean that they're moral or right. It means that these are the rules that the government has decided are the proper thing to do. You can act immorally and legally. One can, lying is immoral, but it's not against the law, except in very certain limited circumstances. You could act morally and illegally and still break the law. So I want to stress that there's two distinct ideas here: laws that regulate society, morality, which is the right from wrong concept. Laws originate in a democratic society from the people themselves, really the people and the representatives that the people elect to represent their interests, and then from the government implementing those laws. In a non-democratic society, laws will evolve from the ruling group itself, whether you're talking about a king, a dictator, a oligarchy, some ruling party, political party. That will be the origin of the laws for that particular society, which begs a couple questions. First off, what goals should society expect a legal system to achieve? We're going to talk about this idea in class. Also, when the goals of a legal system conflict, how should society decide which goal wins? And again, we'll look at that question certainly from the American legal system, but it's certainly applicable throughout history and also in other countries today. In American law, there are certain sources. The fundamental source of law in America is the Constitution. We're going to talk about each one of these in a little bit more specificity here in a moment. The powers of the Congress, the national legislature, are enumerated in Article 1, Section 8 of the Constitution. The First Amendment protects the freedom of speech of all individuals. Those are sourced in the U.S. Constitution, and every state has a constitution as well. U.S. treaties are another source of American law. The North American Free Trade Act, for example, NAFTA, or the START Treaty, which are arms limitations treaties between America and the Soviet Union and then its successor state, Russia. Laws passed by the national legislature or state legislatures and approved by the appropriate executive, whether that's the United States president at the national level or governors in each of the states. The Affordable Care Act, aka Obamacare, is an example of a legislative act that became a law. Executive department rulemaking. Executive departments such as the Department of Homeland Security or the State Department at the national level, or the Department of Health and Human Services, or the Federal Highway Administration. There's innumerable agencies, and this link here will bring you to a bunch of examples. They make rules to implement the laws passed by the legislature with much more specificity. And of course, judicial decisions, acts by the courts, which interpret laws or the Constitution itself. The courts, both at the state and national level, have a specific role in determining the constitutionality of a particular law passed by the legislature. Roe versus Wade established a nationwide right to an abortion back in 1973, for example. Now, constitutions are a document that lays out the organization and fundamental rights of government and the people in that state, it is the supreme law of certainly the United States. It wins any conflict, including a conflict between the national constitution, the U.S. Constitution, and a state constitution. See the Civil War and Reconstruction, for examples. The 13th, 14th, and 15th Amendments, the 14th Amendment in particular, which was implemented to assure that state constitutions complied with the establishment of rights for the former slaves coming out of the Civil War, the newly minted African American citizens. The U.S. Constitution, this link links directly to the transcript, a PDF of the U.S. Constitution, is a basic framework for the government. It lists the government's powers. The legislature shall have these powers. The executive branch should have these powers. It expresses the rights of the citizens and thus limits on the government's powers, particularly, but not exclusively, in the list of the 27 constitutional amendments that have been added to the Constitution since its ratification back in 1789. Each state has a constitution as well. This is a link to Illinois' Constitution, which was adopted in 1970, which again lays out the framework of that state government as well. So these are fundamental law. They are supreme in their particular jurisdiction. Treaties in American law. Treaties are an international agreement that has received in America, that has received the advice and consent of 2/3 of the United States Senate and then is ratified by the President. So the State Department negotiates a treaty with another country or some foreign entity. The U.S. Senate gives its advice and consent, and if 67 senators approve, then the President ratifies the treaty. Now, if a treaty is ratified by a president, then that treaty takes precedence over U.S. national and state laws, regulations, and judicial decisions. It has the force just below that of the U.S. Constitution. Okay. Now, a question we're going to address in class: why has the U.S. historically entered into relatively few treaties? Think about it. Now, legislative acts, what we call laws. The national legislature in America is bicameral, meaning there are two chambers, the House and the Senate. The House of Representatives has 435 voting members, and it's based on proportional representation of, or excuse me, a proportional plan based on the population of each state. Their representatives are elected to 2-year terms, and so if there's more people living in a particular state, you get more representation in the House. So California has lots and lots and lots of people living in it. It gets 53 representatives. Wyoming doesn't have very many people living in it. They get 1. Now the U.S. Senate has equal numbers of senators. There are 50 states. There's 2 senators per state. So every state gets 2 senators no matter how many people live in it. They're elected to 6-year terms. So you have 2 chambers, the House and the Senate, each with different focuses, with different emphasis, and with different interests. Members introduce bills, which go through a pretty involved process through committees and amendments and House floor and Senate floor debate. And if they go through this deliberative process and come out the other end and are passed identically from both chambers, they can be signed by the President and become a law. Every state system has tweaks on that general approach, but 49 of the 50 states are bicameral. Again, they have 2 chambers with one exception. Nebraska is unicameral. It has a 1-chamber legislature. Executive department rulemaking. Again, The president is the head of the executive branch, and of course, a governor is the head of the executive branch in each state. They have millions of employees working for them. When we think of the word government, the executive branch is what almost certainly you're thinking about. Okay, it has millions of employees. Okay, we're going to play a little game in class where we're going to name a department, a federal or national government department, just go around the room with very little preparation, because there's so many of them, we shouldn't have a problem. You can see in this image on this page some idea of how many departments and national agencies there are. These agencies enforce or execute, hence the name executive, enforce the laws that are passed by Congress, signed by the president. Agencies are authorized to make their own regulations to implement the law that established the agency. For example, the Department of Homeland Security was established by an act shortly after 9/11, and then the department began creating regulations to put the will of the Congress, and hence the will of the people, into effect. And they've written tens of thousands of regulations regulating how large of a shampoo bottle that you can put in. Congress doesn't pass a law to tell people how big of a shampoo bottle they can include in their carry-on luggage. That is a regulation written by the Department of Homeland Security. These agencies, this is the single most influential part of government over the day-to-day activities of citizens, okay? Especially at the state level. Oh my goodness. The regulations of you driving your car, of what you eat, most of this is at the state level. Some's at the federal, the national level, don't get me wrong, but this is the executive department rulemaking is a very, very quietly area of intense regulation of the American people. Judicial decisions, of course, also interpret and create rules for us to follow. The U.S. courts interpret the Constitution, the laws passed by Congress, the regulations adopted by federal agencies determine if they are constitutional or not. So, Brown versus Board of Education, 1954, U.S. Supreme Court case that eliminated the idea of separate but equal facilities for whites and blacks in America with, quote, all deliberate speed. Heaton versus Quinn, a state law that was struck down by the Illinois Supreme Court that affected state pensions in Illinois. A law was passed. The state judiciary said this law is not constitutional. A court can even overrule an earlier judicial decision that it no longer finds constitutional. This whole power of determining constitutionality is referred to as judicial review. We'll talk more about that in class. And again, state courts concern themselves with state laws passed at the state level. National courts handle both state and federal laws. More about that when we get to the section of the class based on the court system, the judicial system. Stay tuned. Now, here's the order of precedence of law in America. You could think of this as like a power ranking. What's most important? The U.S. Constitution, as interpreted by the national courts, and in particular the U.S. Supreme Court. Just below the Constitution are international treaties, okay, ratified and consented to by the U.S. Senate, ratified by the President. Then national laws, as interpreted by the national courts, and then the rulemaking from executive branch agencies, as of course interpreted by the national courts. Then we get into states. At the state level, state constitution is supreme, as interpreted by both the national and state courts, state laws, state administrative rulemaking. So each level above is supreme over a level below. We'll talk more about the conflict of these laws as the class goes on. Otherwise, I bid you a fond farewell, and I will see you in class.